Good afternoon. We welcome you to eEthics, Successfully Navigating Social Media and Technology in Marketing Your Practice and Representing Clients with Scott Garner and Suzanne Spencer, presented by the California Lawyers Association. We hope you enjoy the program, and we thank you for joining us today. A PDF copy of today's presentation has been made available to you to print or download. You may access this document by clicking the Resource tab on the left side of your screen. You are encouraged to submit questions at any time throughout the broadcast by selecting the Forum tab, which is on the left side of your screen. Simply type your email address and your question and click Submit. Questions will be answered at the end of the program, and questions not addressed within our available time may be answered by way of post-conference email. At this time, I'm happy to introduce your presenters. Suzanne Burke is a managing shareholder of Sell Spencer Callis and Krieger in Laguna Beach, California, with an emphasis on practice in legal ethics, professional liability, and commercial litigation. She is a former chair of the State Bar of California's Standing Committee on Professionals' Responsibility and Ethics. Currently, Suzanne is co-chair of the OBCA Professionalism and Ethics Committee. Scott is a partner at Umberg Zipser in Irvine and has a focus of practice in business litigation with a particular emphasis on defending lawyers, law firms in legal malpractice, and other lawyer liability litigation. He is currently the co-chair of the OCBA Professionalism and Ethics Committee and has been a member and chair of the State Bar's Professional Responsibility Conduct. He is currently the president-elect of the OCBA and will be president starting this January. At this time, it is my pleasure to turn the program over to your presenters. Please begin.
Thank you. So this is Scott Garner, and I'll be starting out, and Suzanne and I will be jumping back and forth. So the first thing we want to talk about, just to frame some of these issues, is hopefully everyone knows that about a year ago, California embarked on a new set of rules of professional responsibility and conduct. And this is following probably a 15-year effort to change the rules. Some of these new rules do touch on some technology ethics issues that previously had been in the ABA model rules, and there's still changes that may be coming. So we thought it was important just to give a quick intro on the new rules, and really just to point out that one of the things that will be the most stark to people that haven't necessarily followed this is the numbering system has changed. California was the only state that did not follow the model rule numbering and format. And finally, a year ago, California joined the other states and did jump into the model rule format waiting pool. Now, there's still a lot of differences, so don't be fooled and don't pick up the ABA model rules and expect it to be identical to California, but at least you'll recognize the format. Rule 1.6 in the ABA rules will now be 1.6 in the California rules with some differences. But so that's a different thing. I like pointing out that we used to be members, we being lawyers. Now we're referred to as lawyers in the rules. Another change that you'll see is definitions now appear in the, there's a definition section, Rule 1.01. Those used to not be a separate section. They just appeared in the rules where they were cited. And they are followed now by an asterisk where you have a defined term. So if the word knowingly appears somewhere, and that's a defined term, you'll see a set of asterisks around that word when they appear in the rules. So these are just some very general things, changes. But now we're going to just jump into the main topic, which is we call e-ethics, but it's technology issues that arise in different areas. And by way of background, a lot of the ethics rules have always been applied to technologies as they come out. The problem is that they don't always neatly fit, as you can imagine. So, you're talking about things like communicating with a client. All of a sudden, a newfangled technology called email comes up, and people start freaking out. Can you use email to talk to a client? Or would that be something that would be too risky because maybe there's an email server, whether it was AOL back in the day or Yahoo, are they looking at these confidential emails? And so you always have questions, and what you always have is people trying to apply these rules written long before the technology emerged to specific technologies. So point out a couple rules and then a particularly important California ethics opinion. So ABA Model Rule 1.1, which is the competence rule, right? It tells you what you have to do to be a competent lawyer. They have a specific comment that deals with technology and basically says, to be a competent lawyer, you have to keep abreast of changes in the law, including changes to and availability of technology. So again, using my silly email example, 30 years ago, when email was coming up, you needed to at least be aware that, hey, there's this new way to communicate with clients. And obviously, with every change, you need to at least be aware. It doesn't mean you have to adopt all the new technology, but you should at least be aware of it and be able to assess whether this is something that I should be thinking about. Should I be in the cloud? That was a conversation that 10 years ago people started having, and it's changed a lot since then. It used to be thought of as a big risk to go in the cloud, and can you really go in the cloud? Is it secure enough? I think now most people think the cloud is probably more secure than having a server at your office. So, things change, but we're still applying the same rules. Ethics opinion, and by the way, there's no California analog to Comment 8, although it's being proposed now by the State Bar to maybe add something like that, and I think it's actually identical. So we'll see where that goes. The State Bar opinion 2010-179, so this is now almost a 10-year-old opinion, it's sort of generally referred to as the technology opinion. And it talks about when you adopt a new technology in your practice, what considerations do you have to think about? Can you just automatically, jump on any new technology or not? And, again, I hark back to, these early discussions. Can you use email? Can I use a laptop and go to Starbucks and use a public Wi-Fi? Right? There's all these issues. They're constantly changing as new technologies developed. Can I use can I have my client sign an engagement letter with an e-signature? Again, all new things. So this opinion goes through and sort of discusses some of the factors you want to consider. So one of the factors is the level of security that is attendant to that particular technology, including whether you can take reasonable precautions to increase the level of security. So, for example, I use my iPhone for work and I bring it around different places. There is a risk that if I leave it laying around somewhere, someone may find it and jump onto my email and see stuff that they shouldn't see. So are there security provisions available that are easy to use that I should be using? Well, one obvious one is to have a password protected. It's not hard to do. It's not expensive. The law probably requires me, under this general analysis, to use that basic precaution because it's easy to do and it would help security a lot. Another factor is, what are the legal ramifications to a third party who intercepts? So if somebody steals my iPhone and starts accessing things, would they be violating some law? And if so, that means the law is at least in part trying to protect the technology I'm using, and that would be a factor in favor of me being able to use it. The degree of sensitivity of the client information, always important. If you represent Apple and you're prosecuting patents on the latest version of their iPhone, they are hyper secure and concerned about security. And so maybe they don't want you having, copies of some of the technology on your iPhone. Maybe they only want you using it on a secure desktop computer in your office. So again, depending on the sensitivity, there may be more measures you have to take. What would be the impact of an inadvertent disclosure, right? Remember the Apple engineer who left a napkin in a bar that had some secret language or whatever it had on there, the secret Coke formula. That was a real problem. It was inadvertent, but that was a real problem. And so if that's going to be a real problem for your client, if you accidentally leave something around, that's a factor to consider. The urgency and the need to use the technology. If I travel a lot for a client, then I probably need a laptop that I can bring that has client information on it. There's some urgency to that. I can't do my job without it. That may not be true for all lawyers. And then, of course, the client's instructions are always important. If Apple says, under no circumstances may you put our data on a laptop, you probably need to follow that instruction. So that's something to consider as well. So this technology opinion, as you'll see, and we'll sort of hark back to that as we go on, these issues come up in all different kinds of contexts and become important. With that, we're going to switch topics for a minute, and I'm going to turn it over to Suzanne.
Right, so we're going to talk a little bit about social media, and this is an area in which the use of social media has really obviously mushroomed in the last several years, and there's several ways that it can be potentially used as it relates to the practice of law. One, of course, is using it to market your practice. Another is to use it as a research tool, maybe to get information about witnesses or potential jurors. And we're going to talk a little bit about both of those, and also using it as evidence in your case. What can and can't you do? Social media has become an important source of evidence in certain types of cases in particular, such as, say, personal injury cases, or cases where you're claiming that your life is limited now, your lifestyle is limited based on an injury or based on some damage that you've suffered, and your social media page may be plastered with pictures of you out on partying and traveling the world, and so that type of thing may cut against your claims in the case that your lifestyle is limited. So we'll talk a little bit about what are the ethical obligations of lawyers with respect to the use of social media as evidence as well. And so first, let's start talking about the use of social media to market your practice. And this is an interesting area in which the rules of professional conduct have changed pretty significantly. We used to have one rule of professional conduct that governed advertising, and it was Rule 1-400. And then after that, there were 15 standards that basically set forth different types of communications that would be considered presumptively a violation of the rule. And Rule 1-400 applied to communications, and communications was defined as basically communications in any format that were about the lawyer's availability for professional employment. And now we have, in the new rules, we have five separate rules that address advertising and solicitation. And there is permission granted for the Board of Trustees to adopt standards under these rules. But so far, those standards have not been articulated, and I honestly don't know if they're in the books or if they're in the works or not. Because what happened when 1-400 and its 15 standards, when that was changed to Rule 7.1 to 7.4, almost everything that was in the standards has wound its way into one of these rules or the comments following one of these rules. So most of it's there, and I don't know if there will be additional standards coming. The other area where we see regulation of attorney advertising is in the State Bar Act, which is Business and Professions Code 6157 to 6159.2. And I note it because it's something that you would certainly need to be aware of if you're using social media to market your practice. If you're in an environment where you're paying for maybe you're paying for a better listing or paying to be featured, for example. So if you're paying for the advertisement or the communication, then it is an advertisement under the State Bar Act. So because social media, generally speaking, people aren't paying for it, it's not something we're going to emphasize in the discussions today. We're really going to be looking at the rules. But I note it because it's important, because now more and more we're seeing some different arrangements, like on Avvo and elsewhere, where you can pay to have your listing featured. And in that case, you're probably then triggering the obligations of the State Bar Act, which are materially different for this purpose. So it's something to be aware of. So starting with 7.1, which is the the general rule on what you can't do with respect to lawyer advertising. The other rule, there's just a general, 7.2 is the general rule that says lawyers can advertise, basically. But 7.1 is the one that's telling you any communication about the lawyer or the lawyer's services is a communication that's subject to this rule. So note how much broader that is than the communication definition from 1-400. Before, it had to be about the lawyer's availability for professional employment. Now it's a little bit broader. It's, any communication about the lawyer or the lawyer's services is subject to the rule. And what the rule prohibits, probably obviously, is that you can't have any false or misleading communications. So if you're making a communication that's covered by the rule, it can't be false or misleading. False or misleading means not only just affirmative misstatements, but it also means statements where there's an omission. You omit a fact that's necessary to make the communication as a whole that makes the communication as a whole materially misleading. So you have omissions also being covered here, not just affirmative misrepresentations. You also, interestingly, the rule makes clear that even truthful statements that are misleading will run afoul of the rule. And that's in comment 3 to Rule 7.1. And in that context, misleading is, it's misleading if it creates a substantial likelihood that it will lead a reasonable person to form a specific conclusion about the lawyer or the lawyer's services for which no reasonable factual foundation exists. So this is, maybe the area where you're puffing up your resume quite a bit, where there's no factual foundation for, you saying that you're expert in a certain area. That would be an example of something. Well, I guess in that case it wouldn't be truthful. But there are things that you can say that are truthful, but in context would be misleading, and that would run afoul of the rule as well. The comments include a number of other things that we saw in the original standard, such as statements of express guarantees or warranties are going to be considered misleading. And importantly, though, in the former rules, if you were getting testimonials or endorsements as part of your advertising, you had to put a disclaimer in there, and the disclaimer language was specific. And without that disclaimer, you were presumptively violating the rules. That presumptive violation for endorsements is now no longer. That is not part of 7.1. There is a comment 4 that talks about disclaimers and says it's certainly helpful to have a disclaimer if you're making statements in the nature of a testimonial or an endorsement from a third party, but it's not going to be presumptively a violation if you don't have it. And this is an important difference from the State Bar Act. Remember, the State Bar Act we talked about a little bit before, that covers paid advertisements. In the paid advertisement universe, you do have to have the disclaimer, and even the disclaimer will not necessarily rebut a presumption. So again, I point that out because if you're in a paid advertising environment, what I'm saying about these rules may be different because there are different requirements that apply to paid advertisements. And those are the two last bullet points on the screen. The business and profession code sites there are the ones that apply to advertising. And the language is pretty similar in terms of prohibiting misleading communications, but again, the scope of it is quite different. Another important change in the rules is to the rule on solicitation. So solicitation used to be something under the old rules that was just for in-person contact in-person contact with a potential client. So you have the idea of the ambulance chaser and that being prohibited because of the circumstances. Now, solicitation applies not only to in-person or telephone communications, it also applies to written communications. So first of all, what is a solicitation? It's an oral or written targeted communication by or on behalf of a lawyer directed to a specific person offering to provide, or that could be understood to be offering to provide legal services. So the big difference here is that it's targeted to a specific person. Things like your website, general distribution, blogs, things like that will not be considered solicitations generally because they're to the general public. But if you are, if you have emailing campaigns or something where you're targeting specific people, for example, a lot of people will monitor dockets to see if a certain type of lawsuit is brought, and maybe they'll reach out to contact somebody that they know has been sued to ask about, the potential for representation. That's going to be considered a solicitation under the new rule. And so with respect to in-person or telephone solicitations, anything that's live, there's an outright prohibition on doing it. The exception is if the person that you're communicating with is a lawyer or a family, or someone that is part of your family that you have a personal close connection with, or you have a prior business, legal, professional relationship with. So a prior client, for example. Those are the exceptions, and for those people, it's not considered a solicitation if you're communicating with them. With respect to written solicitations, they are otherwise acceptable unless you've gotten a request to leave the person alone, which seems obvious, or the manner of the written communication isn't intrusive or coercive, that it would constitute duress or harassment. So those are the general contours of the solicitation rule. And again, it doesn't apply to websites. But if you, for example, have a blog or something and you have a forum area where you're potentially, answering live questions, that if the significant motive is pecuniary gain will be considered solicitation. So you need to just be aware that, while social media usually doesn't implicate the solicitation rule, it might if you have this kind of live or a forum area that's live. I think that's an important distinction. So there are a few rules of, there are a few opinions that specifically deal with ethical obligations with respect to different types of social media. And one of them relates to the use of third-party rating websites. I noticed on this slide when I was preparing here today that there's a reference here to California Interim Opinion 12-0003. I think a few days ago it was that interim opinion has now actually been adopted as a formal opinion. I didn't have a chance to update this slide. So the formal opinion is 2019-199. And what this
but it's the same language.
Yes, it's the same language. So I don't think they made, I haven't done a red line against what the interim opinion was and what the final version is, but conceptually it's very similar. And what they dealt with there was, when is a lawyer responsible for the content on one of these third-party websites? When is the lawyer responsible for third-party endorsements, or are they? And what about ratings that are found on some of these websites? So I'm talking about something like an Avvo or a LinkedIn, where Avvo, I know for sure, and LinkedIn I don't think LinkedIn does it as directly, but there are many that basically take the registry information from the State Bar and some official source, and they'll give you a profile in Avvo, even though you didn't ask for it. You had nothing to do with this happening. And here is this profile for you, and it might contain information in there about your, when you graduated, the kind of law you practice, etc. Are you responsible for that if it says that you say practice in securities and you have nothing to do with securities in your practice. And the conclusion that that COPRAC came up with, and I think it's the right one, is that if you haven't adopted that profile by, clicking the adopt button or do something that allows you to control the content, and if you're not using that profile to market your practice, then you're not responsible for it under the rules of professional conduct. And so if it's inaccurate or misleading, it's not an ethical violation. So if you've adopted it and then you now have the ability to control the content, or if, say, you have a website, you say, check me out on Avvo, even though you haven't adopted your profile, under either of, that is something that's going to trigger the ethical rules, and you're going to need to make sure that it's accurate if you're going to be pointing people to it. And so that means that at the time that you adopt it, if it has the wrong year of your graduation or if it has the wrong area of practice, you're going to have to correct all that stuff to make sure that it's not false or misleading. And then, of course, that raises the issue, well, is that just at the time that I adopted, or now do I have to continue to monitor this thing to make sure that it's accurate? And there's a rule of reason, but certainly as long as you're continuing to either use it to market your practice or you've adopted the profile and you haven't abandoned the profile, then yes, you need to periodically check it and make sure that there's that the information is accurate. So what happens if a third party endorses you that you've never met before, or a client posts something on there and it contains inaccurate information about your representation? This guy, they got me a great settlement when in fact you didn't settle the case at all, for example. Are you responsible for third party inaccuracies? And the opinion there concludes, well, it sort of depends. If you solicited that testimonial and now it's on there, you've taken a lot of, and you've taken some control over the content, and you probably have a heightened obligation to make sure that it's accurate. And if it isn't, to take steps to, you might have to end up not using the service anymore or using it to market your practice anymore if it's really got false information in there that you're more or less responsible for putting on there. But if somebody else just comes in and says something inaccurate, you have to take reasonable steps, whether that's putting something in the part that you're able to control, saying, I don't review these posts and I can't attest to their accuracy, or, anything that you can say that can correct any kind of misleading impact of something that a third party is saying without, of course, revealing confidential information. Like you can't say this, that client was the worst client I ever had or something. We'll talk a little bit more about that later, but there's still rules of confidentiality. But you do have to make sure that you do what you can. You can even ask the forum provider to take down an inaccurate thing. They usually don't, but you can ask them. If it's a violation of their policies to take it down, then, you just have to continue to take steps that will reasonably address the problem. And if it's bad enough and you can't do it, then you may have to stop using the website. And you may decide to stop using the website anyway as technology changes. And the opinion talks about what to do in that circumstance, like abandoning your profile. It's not that once you adopt it, you now forevermore have to monitor it. If you decide to abandon it and you no longer want to do that, the opinion suggests some language that you can put in your profile to tell the world that you're no longer, monitoring this and you can't, be responsible for its accuracy. They also talk about ratings and accolades a little bit. You know that some of these websites will rate lawyers, and those ratings can themselves be misleading. So if you're going to put yourself into an environment where these ratings are being attached, you need to find out what the rating protocol is. And no one's going to give you their algorithm, but you do need to know what criteria is the website using to rate attorneys. And if it's on some kind of metric that's irrelevant to the attorney's quality as an attorney. For example, the more you post, the higher your rating goes. The more you post has no relationship to whether or not you're a good lawyer. So that kind of metric is not one that's ethically appropriate. Most of them will give you, most third-party websites will give you information about how they come up with their ratings, and they usually have things like number of years in practice, amount of publication, things like that, which would be appropriate. There's another opinion that talks about specific posts or blogs or tweets, and this is Formal Opinion 2012-186. And what's interesting about this is that I think this is decided under the old rules, but I think under the new rules, some of these would potentially come out differently. But basically, that opinion just looks at different things, blog posts or tweets made by a lawyer and runs through them. For example, the case finally over, unanimous verdict, celebrating tonight. Is that a communication? And the opinion says, no, it's not, because it's not a communication at the time applying the definition of 1-400. That's not a communication, about the attorney's availability for professional employment, so probably not. But under the new rule, I think it might be more arguable, because under the new rule, it's a communication if it's about the lawyer or the lawyer's services. And you could say that's kind of about the lawyer because he's talking about the lawyer's professional performance. So I'm not 100% committed on that, but I do think it's possible that first one might be considered a communication under 7.1, even though it wasn't under 1-400. The next one, another great victory in court today. My client is delighted. Who wants to be next? That's something that's obviously inviting people to contact the lawyer and to engage them, and so would be a covered communication under both the former rules and the present rules. There is other problems with this in that it does basically contain the testimonial. My client is delighted. And under the old rule, you had to have a disclaimer if you were going to do that. Under the new rule, you don't have to have it, although it's helpful. And there's also a potential guarantee. Who wants to be next? Who wants to be the next winner? That's a potential, that's a guarantee of results, and that is something that's prohibited and misleading across the board. There's no disclaimer that can get around that. Won $1 million verdict, tell your friends, and check out my website. Again, this is another, this would be considered a communication, and of course, if you didn't win the $1 million verdict, it would be false and therefore violate the rule. But it would be a communication within the context of the rules, both old and new. The next one, another personal injury case, call me for a free consultation. That would also be a statement, certainly under the current rule, about the lawyer or the lawyer's services, so it can't be false or misleading. There was a requirement under the old rule that some of these things contain the word advertisement, but that is now gone under 7.1. Under these types of communications, under 7.1, you don't have to be putting the word advertisement there. And then the final one, just published an article on wage and hour breaks. Let me know if you would like a copy. This is something that has not typically been considered a communication that's about the lawyer's availability for professional employment, because you're basically providing information of interest and it's your area of expertise. You're not necessarily asking there for employment, although I think we know why you would want the person to be contacting you. It's possible under the new rule that that is a communication under 7.1. Okay, and blogging, this is another formal opinion on blogging, 2016.196, and it's similar in the sense of, blog posts concerning results of cases. If you're, posting about the results of all your cases, those are going to be things that are covered by the ethical rules concerning advertising. And articles of interest related to an area of practice, again, would not. So if your blog is really focused on just providing information, the fact that you're a family lawyer and you're providing information about family law and family courts doesn't necessarily mean that it's subject to the rules of professional conduct, because lawyers, like everybody else, have the constitutional right to speech. So, there's a fine line between what's commercial speech, which can be regulated, and what is you just sharing information of knowledge. So if it's sharing your information of interest or is certainly not covered or regulated. Where it gets regulated is if it goes to the into the definition of commercial speech, and that's why a blog unrelated to the practice of law, but with a link to your professional website, would also not be something subject to the ethical rules. And I guess there was somebody up north that used to review movies or something, and on there, it was a lawyer, and on his professional website, he had a link to his blog where he reviewed movies. That would be an example of the blog not being subject to the rules of professional conduct. And finally, ghost blogging is something that's come up, and recently there's no definite opinion on it, and that's where you have somebody else blog and pretend basically that they're you and write a blog post, and depending on the post, that's probably unethical. Okay, and then in terms of discipline, California hasn't done a ton of discipline in this area, but there is one case, and this is a case where on a website there was a publicity page, and the publicity page had posted pictures of a lawyer with celebrities all over the world, where that really never happened. She never met any of those people. You can see the page here. And so she photoshopped herself in there. And the reason why we don't see a lot of advertising discipline cases is because there's a safe harbor. Usually what happens is that the safe harbor sends you a letter that says, you've got something here that's misleading, it's false, you need to you need to take care of it, and it's only when the lawyer refuses to take care of it. There's also a mechanism for getting a judge basically to look at it and decide whether or not it's misleading if you wanted to take that tact. But basically you have a safe harbor, and most people abide by it, but this attorney didn't, and she did get disciplined for this website. Online reviews.
All right, so we'll talk just a minute about online reviews. And you can imagine it's different when a lawyer gets slammed in a review than a non-lawyer. So if I'm a chef, for example, at a nice restaurant, and someone puts in a Yelp review talking about how bad my food is and my conduct and whatever else they want to say, I, as the chef, can respond on Yelp with sort of, a retort to it that, well, the customer was drunk when he came in, the customer does this all the time, whatever I want to say. And I really have no limits in that case, probably short of defamation, to say what I want. With a lawyer, it's very different. A lawyer is constrained, sort of has his or her, one arm tied behind his or her back, because the lawyer owes a duty of confidentiality and a duty of loyalty to her clients, and that would include former clients, right? So usually if you're getting a bad online review from a client, it's probably from a former client, and if it's not, you should make it a former client. And so you've got these duties to that client. And so what does that mean? Well, there's been now a couple of different bar opinions. San Francisco had one in 2014. LA had one in 2012. And they say essentially the same thing, which is that you may, as a lawyer, respond to that online or similar review. It obviously doesn't have to be online, but that's where these things come up most often. You can respond if you can do so without disclosing any confidential information. So for example, if the client starts talking about all the bad things you did in your representation, it's going to be hard to defend yourself without disclosing things that happened in that representation. But if you can, without disclosing confidential information, that's one thing. You can't do anything that would injure the client or the former client in connection with a matter that you represented that client in. So if you represented a client, in some kind of a criminal proceeding, you really can't talk about anything relating to that criminal proceeding. You can't say anything that would sort of hurt that client in some way. And then the last point is your response has to be proportionate and restrained. So if after preserving their confidentiality and after not saying anything that will injure them in connection with that same matter. If there's anything left that you can say, it's still got to be restrained and proportionate. Only address the specific issue that they raise, and don't just start going off on how horrible of a person they are. All those things can get you in trouble. Now, my advice is it's not worth trying to respond because there's so many ways to get in trouble. But at least if you're going to, those are some sort of guidelines. Now, you see a reference here in the slide to Evidence Code Section 958. Evidence Code 958 is often referred to as the malpractice sort of defense to a attorney-client privilege. It says, there is no privilege under this article as to a communication relevant to an issue of breach by the lawyer or by the client of a duty arising out of the lawyer-client relationship. So the classic way this comes up is a client sues you for legal malpractice. In doing so, he's waived the privilege with respect to communications relevant to your defense. So if he says, for example, the lawyer never told me that I could lose $1 million if I litigate this case, the lawyer can defend himself by saying, that's not true. In fact, here is an email that I sent to the client saying you could lose $2 million, right? But here's the rub. It's got to be in connection with an actual litigation or some kind of proceeding. So if there's an online review that's absent from a litigation, Section 958 doesn't help you at all. Because it's not really a privilege issue as far as evidence. It's really a duty of confidentiality issue. And your duty of confidentiality is not sort of excused just because someone says something bad about you in any context, but certainly in a non-litigation context.
So one other piece that we're going to cover here on social media, and then we'll move on to artificial intelligence, is the use of social media in litigation. And so there's a couple of interesting cases on this point. One involves advising a client to clean up their social media. And this was the Lester versus Allied Concrete case where it was a wrongful death claim husband who lost his wife, and they were in the midst of litigation, and after they had received a discovery request for all social media, the lawyer, and it appears, it's hard to say, but it appears that the lawyer instructed the client, but however it happened, the client cleaned up his social media by basically getting rid of his Facebook presence, and so that they could find a way to say that he didn't have a Facebook page presently, and so didn't produce anything. But somehow the other side, probably through the cache system, was able to find an older version of his Facebook page, and there was a picture of him on it with holding a couple of beers and with a T-shirt that said, "I heart hot moms." And therefore, they thought that might be damaging to his case, and so took it down. The lawyer was suspended for 5 years, and $700,000 in sanctions was awarded against the attorney and client in that case. In the Gatto case, after litigation had already been instituted, the plaintiff deactivated a social media page, and as a result, there was an adverse jury instruction given that whatever was on that page was bad because they deactivated it. And here's the important part. They didn't save whatever was on it at the time they deactivated it. So I don't want to be, anyone taking away from this that you can't clean up your social media or deactivate your page or, just let some horrible piece of evidence hang out there, unmitigated out there, but you have to save it, and if a discovery demand is propounded, you have to produce it. So the issues here were that they were trying to make this stuff disappear, and that you can't do. That is unethical. Friending employees of a represented party. There's an interesting opinion out of the San Diego County Bar Association that deals with, can you friend the employees of a represented party? If they're high-ranking employees, such that they would be considered the client, and that, an employer is represented by counsel, and you want to get into the Facebook, you want to try to friend them so you can see the kind of stuff they're posting about their employer, if that's why you're doing it, then that is an improper contact with the representative party to go in and try to friend them, because the friending makes it look like you want to be friends with them. You're not saying, I'm here to get information off of your Facebook page that I can use against your employer, right? If that was the disclosure you were given, then I guess it wouldn't be misleading. You'd also probably be denied your friend request. But anyway, that's why that's unethical, and there's an interesting discussion of it. And it's similar with friending witnesses or jurors. And, obtaining evidence through social media under false pretenses. And what's interesting about that is that we now have a new rule, Rule 4.3, that prohibits lawyers from misleading unrepresented parties even. So in the area of witnesses or jurors, if you're trying to contact them and you're doing it in a misleading way, then that can be a violation of the rules of professional conduct. That said, nothing stops you from monitoring. This is talking about, friending or trying to make contact with them so that you're given access to more information than would otherwise be publicly available.
All right, so let's turn to artificial intelligence. Artificial intelligence comes up in a number of ways. I mean, I think there's a lot of disagreement about what exactly artificial intelligence is. But in varying degrees, it could be something as simple as some of your Lexis research tools. And when you do certain, searches and have them come up with cases that may be relevant, you also have things that are form-based. And this is really where a lot of the issues come up. So, for example, LegalZoom is one of the big players here, where they have different software or portals that have forms, court forms or otherwise, where a client or a customer can come in and fill out a form. And it goes anywhere from literally just downloading a form and filling it out to answering a few basic questions and then having the program fill it out for you. And so we get into issues of what are some of the issues with artificial intelligence. And the big issue that you see is unauthorized practice of law. These programs and these companies that have these programs, they're generally not owned just by lawyers, right? They're owned by entrepreneurs. There may be a lawyer involved, but there's usually going to be non-lawyers involved. So if you have a non-lawyer running a company that is providing some kind of a legal service to customers, that could be considered the unauthorized practice of law and is illegal in California and really across the country. Business and Professions Code 6125 is again part of the State Bar Act. Says no person shall practice law in California unless the person is an active member of the state bar. And then it goes on. Rule 5.5 says it's a violation of the rules. Business and Profession Code 6126 says it's a misdemeanor. So obviously there are bad consequences if you are a non-lawyer and you're practicing law. So then we have a whole bunch of cases, many of which are actually involved LegalZoom as the big player here, that analyze different types of artificial intelligence or other programs and discuss whether they cross the line into practicing law. So just to go over some of the cases, and some of them are pretty interesting, but even before you get into these LegalZoom, you've got a case from 1970, Barron versus City of Los Angeles. It's a California Supreme Court case, where the California Supreme Court defined the practice of law to include, quote, legal advice and counsel and the preparation of legal instruments and contracts. So, for example, in an obvious example, if you are preparing a will for a friend or family member, you are practicing law, right? You're preparing a legal instrument. You can't do that if you're not a lawyer. It also says that if there's any doubt about whether some activity constitutes the practice of law, that doubt will be resolved in favor of a finding that it indeed is the practice of law. So you've got to be careful. So now we have a series of opinions that have come out, both in California and in other places, addressing different types of mostly form-based companies. So in the list here, In Re Reynoso, which is a Ninth Circuit case from about 12 years ago, a forms company advertised that it offered its customers extensive advice on how to take advantage of loopholes in the bankruptcy code. It described itself as comparable to a top-notch bankruptcy lawyer and described its software as an expert system that knows the law and would do more than function as a customized word processor. Okay, with all these grandiose claims, it's not surprising that the court found that that company was engaged in the unauthorized practice of law, because all of these things weren't just filling out forms. It was much more than that. They were providing services that normally would be provided by lawyers. Therefore, they were engaged in the practice of law, and because they weren't lawyers, it was the unauthorized practice of law. The next case we have, which is actually a little earlier, but it's an interesting one out of Texas, actually the Fifth Circuit, but applying Texas law. It was a Quicken family law software program. The court did find that this program was doing more than just having them fill out forms and therefore constituted the unauthorized practice of law. What's interesting in particular about this case is the result was that the Texas legislature amended its UPL, or unauthorized practice of law statute, to exclude products that conspicuously state that they are not a substitute for the advice of an attorney. So I find it interesting. It's almost like you could do or say anything you want, as long as you then say, oh, by the way, we're not a substitute for a lawyer, even though they clearly are. But that's how the Texas legislature tried to address this issue. You've also got a case in North Carolina where the settlement of the case was a consent decree where the parties agreed that the practice of law does not encompass the operation of a website that offers customers access to interactive software that generates a legal document based on a customer's answers to questions. So again, not clear how far in the North Carolina rule you could go. Are they just asking questions like, what is your name? What is your marital status? Or is it going further and really analyzing data and coming up with choices? So North Carolina, that's how they dealt with it. It's a little ambiguous. South Carolina had a case, Medlock, from a few years ago, 2013, where, again, LegalZoom was involved, and they agreed to a settlement that said LegalZoom agreed that they would only provide forms or offer forms on their program that were the same as the self-help forms promulgated by state and local agencies and the courts, or that were reviewed by lawyers before being offered for sale to customers. Another part of it, the same settlement, was that the customer's answers had to be entered verbatim on the self-help form. In other words, they didn't want the program doing any thinking and how to sort of better word the client's answers. And then, again, similar to what they came up with in Texas, here in South Carolina, LegalZoom agreed that they would include a statement on the website to the effect that LegalZoom is not a substitute for a lawyer. Finally, the last case here is this Jansen v. LegalZoom case, the last one on the list, from Missouri. There, the court did find that LegalZoom was engaged in the unauthorized practice of law, and the portal that was at issue said, just answer a few simple online questions and LegalZoom takes over. So obviously a lot more than just a form-filling program. And so for that reason, you sort of look at all these and say, okay, what can you do? And so I've listed here some of the takeaways. One, the safest course is that consumers input all the information themselves, and that the provider doesn't really change the information. That the provider includes a statement to the effect that it's not a substitute for a lawyer, and that the forms themselves are reviewed by a lawyer before being sold to the consumers. Now, all of this begs the question of, the more limited the program is, right, the less likely it is to run afoul of the UPL laws, but also the less helpful it's likely to be to consumers, particularly consumers that might not be able to afford a lawyer. And Suzanne will talk about some of the policy issues in a moment. The last point on here, though, is, as I mentioned earlier, as long as a lawyer is doing it, none of this matters, right? Any lawyer can sort of use a artificial intelligence program under his or her guidance, and then there's not an unauthorized practice issue. But you do have to be careful of supervision. And the analogy is, and we've had cases like this, where a lawyer hires 20 paralegals to do a bunch of work and doesn't really supervise them. Well, the lawyer might have a problem with inadequate supervision and maybe violating a rule. And that would be the same with artificial intelligence. Yes, you can use it under your own guidance as a lawyer, but you can't rely on it so heavily that you're not supervising or directing or at least reviewing in an adequate way the output of the artificial intelligence program.
Right, and as Scott mentioned, the really interesting thing here is you can see from the discussion of all of these cases that you really have to limit what the program can do in order to not run afoul of UPL. And so you're sort of taking the intelligence out of the artificial intelligence. And because of that, it can make it not as helpful to consumers and sometimes harmful, especially in certain areas like immigration law, where if you fill out the wrong form or you fill it out incompletely, you could actually be deported. The consequences can be huge. And so the question now that the State Bar is looking at is, are there things that we can do to increase the use of artificial intelligence to make justice more accessible to people such that they don't have to retain a lawyer for everything? And there's a number of things that are on the table. One of them is non-lawyer ownership of law firms. Another is non-lawyers practicing law, just straight up non-lawyers practicing law. They'll be regulated. They'll be subject to the rules of professional conduct or something like it, but that's on the table. And then something that they call technology-driven legal services delivery systems. They don't want to use the word artificial intelligence, but that's clearly what that is. So they're trying to make space in the market for technology-driven legal services delivery systems. And what that would be is basically programs that are able to do more than what has happened so far, because the UPL laws will basically be changed to allow these certain certified technology-driven legal services delivery systems providers to be certified by the bar, and they're going to be regulated by the bar, I think by the bar, unless they do another offshoot.
Unclear, yeah.
Right, it's a little unclear, but those are the things that are on the table, and the idea is to promote access to justice. Some of the people that oppose this say, well, it doesn't really, the access to justice, a lot of impoverished people don't even have computers, but it's just really about access to justice for everybody, not just for impoverished people. And you would think that as a literal matter that will happen. But anyway, it's out there, something to follow if you're interested in it and you're afraid that a robot's going to start doing your job.
All right, our last topic and our last slide is on electronic discovery. This is an area, obviously, that if you're a litigator, this is huge. It's been huge for a long time, and in some ways it's taken over litigation. Right, this is such a big part of litigation and the expense of litigation. There's a State Bar opinion from 2015 that goes into a lot of detail about what your obligations are with respect to electronic discovery. It starts out by saying, look, this is an issue of competence, and competence is one of the big issues that you have to consider. But to be competent, a lawyer must have the learning and skill and mental, emotional, and physical ability reasonably necessary for the performance of such service. Rule 1.1 also goes on to say, though, that if you don't have sufficient learning and skill, you can nonetheless provide competent representation by associating with, or where appropriate, professionally consulting another lawyer who you believe to be competent, or acquiring sufficient learning and skill, or just referring the matter out. So in the context of electronic discovery, you've got a case that's got a ton of issues with respect to electronic discovery, which is most cases now, and you decide, I don't know anything about electronic discovery, and frankly, I don't want to learn about electronic. I don't know what a TIF is. I don't want to know, all this stuff. Well, one thing you can do is associate someone in. Now, the rule specifically refers to associating in another lawyer. I think you probably could associate in a discovery company. But this is now you get into issues of supervision, right? You can't bring in a discovery company and just completely turn it over to them. You've still got to supervise. Hire a millennial, right? They're going to know more about this stuff. But again, if it's a new lawyer, you want to supervise that new lawyer. So you've got to make sure you understand it. And I always say, look, you need to at least know what you don't know. So you need to know what the issues are. Like, there may be some small cases where you don't really need to get into subpoenaing a bunch of electronic discovery. They can maybe print out a handful of emails and there's a contract and that's about it. But you need to at least know what's out there, what your options are, both when you're on the defense side or on the plaintiff side, as far as getting documents versus defending the production of documents. And you have to understand it in order to be competent, and that's what this opinion says. You've got to understand your duty to supervise, whether that's another attorney in your firm, whether it is an electronic discovery company, or frankly, even the client to some extent, if you turn over a lot of that to them. And then the duty of confidentiality, right? You're dealing with documents that might be confidential. This opinion makes it clear that you've got to handle that discovery and that data in a way that preserves the confidentiality. And with that, we are at 1 o'clock. So I think we are concluded.
Thank you, everyone.
Thank you very much, Scott Garner and Suzanne Spencer. We also thank each of you for participating in today's program. This concludes eEthics Successfully Navigating Social Media and Technology in Marketing Your Practice and Representing Clients, presented by the California Lawyers Association. Thank you again for attending. Have a great day, and you may now disconnect.